Family mediation specialists versus family law litigators. Which one is better for high asset divorces? Most people assume that high asset divorces automatically require courtroom battles. The surprising truth is that mediation can sometimes preserve more wealth and relationships than litigation. Family law litigators are experts in courtroom strategy. They handle asset division, child custody disputes, and complex financial arrangements. In cases involving substantial property, business interests, or offshore accounts, litigators ensure their clients' rights are protected and aggressively advocate for the best possible outcome. Family mediation specialists, on the other hand, focus on negotiation and collaborative problem solving. They facilitate discussions, help couples reach mutually acceptable agreements, and often reduce legal costs and emotional stress. For instance, in a divorce involving multiple properties and investment portfolios, a mediator can guide parties to equitable settlements without the drawn-out process of court proceedings. The key difference is adversarial versus cooperative resolution. Litigation can secure legal victories, but is costly and time-consuming. Mediation encourages collaboration, reduces conflict, and can protect assets from erosion by legal fees. Many high-asset cases benefit from a combined approach. Mediation is attempted first to reach agreements, and litigators step in for unresolved disputes or enforcement issues. The takeaway is simple: choosing the right path depends on the couple's willingness to negotiate and the complexity of assets. The surprising truth is that mediation, even in high-net-worth divorces, often delivers faster, less costly, and more controlled outcomes, while litigation remains the essential safety net for unresolved or contentious issues.